Welcome everyone to our first seminar for MCHSA of the fall semester. We have a wonderful speaker with us today. So I'm just going to give a brief introduction for her. So Lauren Booth is our speaker. She joined A Better Balance as a staff attorney in January of 2022. She's based in Montgomery, Alabama, and she works on state and local policy, advocacy, community outreach, and education efforts to help working parents and caregivers understand their legal rights in the workplace. Lauren has engaged in multiple public speaking engagements, such as presenting monthly Know Your Rights trainings for Jobs to Move America and Alabama WIC. Lauren received her JD from Temple University, Beasley School of Law, where she served on the executive board of the Student Public Interest Network and the Black Law Students Association. And prior to joining A Better Balance, Lauren clerked for the Honorable Susan F. Mavin of the New Jersey Superior Court Family Division. So I want to give a warm welcome to Lauren, and I'm excited to hear your presentation today.
Thank you. So we're just going to jump right in. Again, we're going to go over legal rights for pregnant and breastfeeding people in Alabama. So that's me. Lauren is a staff attorney, has already been introduced. And that's my email address if there's any questions after the fact and anybody wants to reach out. So the kind of lay of the land here that I'm going to give is any questions, feel free to put them in the chat. I'll try to get them to them today during this session. If not, I'll always follow up with people. And then in the chat, if people can put, if you're a student, like what is your area of interest? Graduate students, what are you working on right now? Or if there's any providers or anybody else like that joining us, you can introduce yourself in the chat. Okay, so a little about my organization, A Better Balance. A Better Balance is a nonprofit legal advocacy organization. We use the power of the law to advance justice for workers so they can care for themselves and their loved ones without risking their economic security. We believe that when women, caregivers, and families have a fair shot in the workplace, our families, our communities, our nations are healthier and stronger. We engage in advocacy at the federal, state, and local levels. I'm here in Alabama, so I work on local and state initiatives as well. So some of our key ABB policies and priorities that we have are around pregnancy discrimination accommodations, lactation discrimination accommodations, paid leave, family and medical, paid sick time, caregiver discrimination, and flexible scheduling and those types of workplace accommodations are sort of our key policy issues. And then I should also mention before we get started that in addition to the advocacy work that we do, we also have a free and confidential legal helpline that is staffed by attorneys at the ABB, taking calls from across the country for workers who might be experiencing issues or difficulties at work in any of our kind of core issues. And then we also have some direct representation that we do if people come in through the helpline and it ends up being a case that we can take on, but in a limited scope. So yeah, just wanted to also kind of put out those are the other things that we engage in. Okay, to get started, I kind of wanted to just put out the kind of like lay of the land, the status of women in Alabama, facts that I'm sure you're well acquainted with, March of Dimes. Alabama's an F for its 2021 preterm birth report card. Have a percent here, 12.9% of babies in the state are born preterm, and preterm rate among Black women is 52% higher than the rate among all other women. So large disparities that we're seeing there. Also, when we factor in race. And then we also want to take a step and also look at the economic side of this, which is that women are important and crucial to Alabama's economy. We need them. We won't have a successful economy without women. But we know that they're not participating in the workforce the way that they can. And we have here that studies have shown that 52% of working age women in Alabama are participating in the labor force compared to 63% of men. So there has to be something there that's causing 11% dip for women participating in the workforce. And then also what we found interesting is that this is not just that this situation is also being amplified in Alabama, because across the southern region, women participation rates are actually higher. And Alabama is ranking on the lower end of women participation. So specifically in the state, there's work that needs to be done to get women back into the workforce and improve the economy. And I always like to kind of throw in the economy piece, because when it comes to this work and the way that we approach it and advocacy in general, you have to look at issues from all different sides. And while yes, the health issue is so important and it's crucial, you can see how we need it, you also have to look at the economic issue when you're talking to policymakers and the business community and people like that, in order to make the strongest point to see why we actually need certain changes and why things need to change. So that's kind of why we get both the health and the economic here. And then this is sort of our legal lay of the land. What does it look like legally to be a pregnant worker in Alabama? Well, currently Alabama law does not explicitly provide reasonable accommodations for pregnancy, childbirth, or other pregnancy-related medical needs, or any paid family medical leave or paid sick days to employees, as in like mandated by the state. There is no state law that said it. Some private companies, of course, can offer these, but we're talking about across all employers. And we know that without stronger legal protections, pregnant workers who need accommodations, they're either pushed off the job, they have to resign. Again, we're lowering our workforce and labor force participation, or they're continuing to work and jeopardizing their health. And we know that some of those issues when we come to work are what can lead to preterm birth and low birth weight, because women are working when they shouldn't be, because they don't really have a choice. And so our goal here and part of our advocacy work is kind of showing the policymakers, legislators, that supportive workplace policies, accommodations, paid leave, that we can help increase our labor force participation and avoid increased health risks, decrease our preterm birth rate, and low birth weight around pregnant people in Alabama. So that's sort of where we are right now. And how we approach this work and this framework when it comes to an advocacy lens. Now for the fun stuff, the law. Just a little intro. This is a little bit of overview of what we're going over today. I just want to make sure that this is clear. These are all federal laws, because as we just said, we don't have Alabama state laws that are affecting these specific populations that we're talking about today. We're going to go through each one, give a little rundown of what the law actually means. And then we have some fun little scenarios. We can get some engagement from people. That's always a highlight for me. So let's get into it. Okay, first and foremost, the Pregnancy Discrimination Act. The Pregnancy Discrimination Act, which I'll refer to as PDA, it's a federal law that prohibits the unfair treatment of workers because of their pregnancy, childbirth, or related medical conditions. Related medical conditions does include lactation in this interpretation, and it is applicable to employers with 15 or more employees. And the law says that an employer cannot discriminate against an employee in any aspect of employment, so hiring, firing, promotions, etc., because of their pregnancy or childbirth or related medical conditions. Another thing that we kind of see when we come to this hiring, firing kind of way of thinking about it that comes up a lot, and we hear in like our helpline, is pregnant people having their hours cut because they're pregnant and stuff like that. You can't just cut somebody's hours simply because they're pregnant. That is illegal discrimination. And then also it takes in harassment, which is defined as something that is so frequent and severe that it creates a hostile or offensive work environment, or when it results in adverse employment decision like being fired or demoted. Also want to note that a harasser can be a supervisor in another department, a coworker, or someone who's not an employee. Another aspect to the PDA, besides prohibiting discrimination, is that it may help workers receive minor job changes or accommodations to stay on the job and stay healthy. A covered employee may have the right to receive a reasonable accommodation for pregnancy, childbirth, or related medical condition if an employer provides accommodations to other employees who are similar in their ability or inability to work. That's a mouthful, yes. Kind of an example is that if, again, if an employer provides smoke breaks to other employees, but refuses to provide a pregnant worker additional breaks to pump or use the restroom or have snacks, that could be a violation of the law. So not treating somebody that's in a similar role and capacity in their job and giving them specific treatment just because they're not, giving them specific accommodations and they're not pregnant and denying that to the same type of accommodations to a pregnant person, that can be illegal. Again, the PDA, there is gaps here in this law, and those another thing that we always have to be thinking about federally, 15 plus employees, where the smaller businesses are not being covered. This standard where it's like you have to have a similar situated employee, that can also be kind of difficult and a high bar to get to in order to prove your case when it comes to getting accommodations. Next is the Americans with Disabilities Act, the ADA, another federal law here, applies to employers with 15 or more employees, just like the PDA. The ADA makes it illegal for employers to discriminate against workers with disabilities, and it requires an employer to provide reasonable accommodations or minor job changes, as we call it, to employees with qualifying medical conditions, unless it would impose an undue hardship on the business. We have here undue hardship means it'd be too expensive or difficult. And of course, with these accommodations, you still must be able to complete the basic duties of your job. And then under the ADA, the definition of disability under the ADA is a physical or mental impairment that substantially limits one or more life activities. So it has to affect either, performing manual tasks, seeing, hearing, eating, sleeping, walking, standing, breathing, etc. And I know probably reading this, you'd say, well, pregnancy should fall under that because it can substantially limit a lot of these functions, but no, pregnancy itself is not a disability under the ADA. But what can be are pregnancy-related illnesses, high blood pressure, severe morning sickness, gestational diabetes, mastitis. Those are issues that would qualify for a disability under the ADA, and so therefore you would be entitled to an accommodation using the ADA. Some examples of accommodations under the ADA. These are usually, pretty quick, low cost accommodations that employers can enact, access to water, just having a water bottle, transfer to a different position, shade, stool to sit on in your during your shift, some rest breaks, time to take medication, etc., and temporary relief from heavy lifting are some of the really common examples that we see of accommodations that, again, are low cost and have a low burden on the employer. So when speaking with workers, we always advise them to kind of follow these 3 general steps when it comes to talking to their employer about getting an accommodation or a job change. One, first and foremost, look at your employee manual. What policy and procedure does your employer have in place for requesting accommodations? You need to abide by that if they have a set procedure. And then 2, once you go and you notify the appropriate way of doing it, you need to make sure that your employer knows that you need a change for a reason related to a medical condition. They can ask for a provider note, which we will get into a little later, but it is not always needed. And you always should come prepared and be clear, what kind of accommodation you need and how you think that, and how you believe that you can get this and get your job done. And then third, this whole process, and what you keep in mind is that this is an interactive process, means there's a conversation on both sides. You go to your employer, they need to respond and be mindful and have that conversation to see how can we get an accommodation that works for you and gets you to stay in your job and get your job done. Just note that you may not be able to get your first accommodation, but your employer does have to engage in that process and offer an alternative accommodation. And they can't just force you to take unpaid leave if they have another option or accommodation that they can offer. Next here is provider notes. So I said earlier, some employers may require a note, and these are sort of just common things that we've seen as good practice when it comes to provider notes. We have on this first one, try to limit, blanket restrictions for all pregnant patients. Again, so just saying all pregnant workers should refrain from lifting over 20 pounds in your provider note. That's not going to be, as helpful. It really should be tailored to that specific person that you're talking about and their specific situation. We want to avoid listing particular accommodations in that saying like X person needs light duty, is that's the accommodation, that's it. Because maybe that's kind of closing the door to other alternatives. Instead, kind of say what exactly your client needs in order to do their job. Like they need to refrain from lifting over X amount of pounds, etc. Instead of putting the accommodation first and not having the evidence behind it. We also want to make sure we're not making it vague or overly broad. Just avoid heavy lifting, period. That's not as helpful, because what does heavy lifting mean, and what exactly are you talking about? How much weight exactly are you thinking about in this situation? What is something that, what can your specific patient or client actually do? That's what you want to put in there if you can. So be specific again. And then lastly, just avoid misspelling, typos, illegible writing, doctor's handwriting. Let's try typing them. That's always great. We want to make it so that employers can read these, see these easily, don't have to be squinting and asking, what exactly does this mean? And then we also know that sometimes we've had employers ask, patients, their employees, to go back to the doctor and say, can you get this rewritten? And it's just like, that's just wasting everybody's time and delaying the employee from getting the accommodations that they need. And then also just kind of best practice as well is like doctors can always, they can ask the worker too, and the worker can work with them and see if they've got a note in the past. This is an example of what my doctor previously wrote. Can you do something like this? That's always nice to, at least provide some sort of example if you can, if you've had that situation before, and maybe this is just a new provider. And that can be helpful going through this process. Here we have a good example of a provider note. You see here on June 15th, my patient was consulted with me in my office. I diagnosed the patient with pregnant with carpal tunnel. Consistent with this diagnosis, they need accommodation at work until their baby is born. And then they're going into some details here because of their carpal tunnel syndrome and associated limitation on repetitive use of both hands for more than 30 minutes without a break. Again, putting in kind of numbers and specifics here. She has difficulty for typing for a long period. She will have to take 5-minute breaks after 30 minutes of continuous typing. Again, being as specific as possible, which is helpful for the employer as they're trying to navigate this process. I want to say that not all notes need to look like this. This is just an example. Maybe it doesn't need to be this long or kind of worded exactly this, but your goal at the end of the day is to get specific information about your patient and make it clear for the employer to know what they actually need and what the type of accommodations that they would actually need to stay on their job. Our website, ABB's website, and we also put on here a jobs accommodation network, askjan.org. They have more resources about doctor's notes, and we also more than happy to talk through the process of getting a provider's note with clients who call our legal helpline, and can kind of walk through what that process would look like for that person individually. Okay, so enforcement. So the two laws that we just talked about, which are the PDA, Pregnancy Discrimination Act, and the Americans with Disabilities Act. Enforcement is through the Equal Employment Opportunity Commission, the EEOC, mouthful. This is again the federal agency that enforces anti-discrimination laws, and that these apply to businesses with 15 or more employees, as I mentioned. An employee has 180 days in Alabama after the alleged act of discrimination to file a charge, but there might be some situations where you have more time if there's a continuing pattern of discrimination. You can file online, by the phone, mail, or in person. Again, we have our helpline there, happy to help people walk through that process with them and kind of see what next steps they need to have in order to file a claim, if that's what they need to do. So now that we've gone through those two laws, we have some more fun coming, which are some scenarios. We have a test, a quiz, which I'm sure you guys don't want to hear about anymore. So scenario one, Jane works at a large fulfillment center in Alabama. She recently gave birth to a baby boy. Jane still has chronic back pain, which started during her pregnancy, but it's not clear that she has a pregnancy-related disability. What are her rights? Are there any changes Jane can ask for in the workplace to stay healthy while working? So in the chat, if anybody wants to put any ideas they have, maybe what law would apply that we just went over, one of those, or any changes that you think Jane could ask for that could keep her in this job and stay healthy. I'll give you guys a minute or so. Not seeing anybody in the chat. Are you guys there? No, it's okay. I know it's a Thursday. It's at it's a little afternoon, kind of nighttime now. So I'll chug along. But please, if you have any comments or anything like that, please put them in the chat. So here, Jane may be covered under the Pregnancy Discrimination Act. Using the PDA, she may be able to request accommodation or a minor job change, which would be maybe the use of a stool or a position where she could stay seated while working, but only if other employees are being accommodated. So again, you know, if somebody else is getting a smoke break, then they can't deny a pregnant worker a break to, you know, pump. Then in the situation, another person would be getting accommodated. They can't deny her an accommodation simply because it's dealing with pregnancy or childbirth. And then she's also protected from facing discrimination or unfair treatment because of childbirth. I want to just note that in this scenario, we're going with the PDA because, as we had in the last slide, it's not clear that she has a pregnancy-related disability, so therefore she wouldn't be covered under the Americans with Disabilities Act. And back to the idea of asking for an accommodation in the PDA, with that similarly situated another employee thing, that can be a high bar. And we're having, you know, workers do face issues, and we hear about finding somebody else similarly situated in their ability or inability to work. And that's, you know, definitely something we advocate around, and in changing the law to make it extremely clear that pregnant workers deserve to be accommodated without having to do that. But that is the current state of the law right now. Okay, we have what accommodations she eligible for if no other employees are getting accommodations? None at all. Yeah, she would not be able to, under the PDA, have an accommodation if nobody else is being similarly accommodated. And that, you know, of course, doesn't make a lot of sense, but it is the way that the law is written. So a lot of pregnant workers do get denied under the PDA access to accommodations, which is unfortunate. And then next question, why can't she use the ADA for back pain independently? of the pregnancy. If the back pain rises to the level of a disability, which we discussed earlier, which is substantially limiting one or more of these functions that I had mentioned, then maybe yes, she would qualify under the ADA to ask for that accommodation. But we don't know in this situation if it's clear that the back pain that she experiences is a disability. And that's the reason why I didn't mention the ADA in this situation. But good questions. Okay, scenario 2. Mary works for a large retailer as a cashier. She is 6 months pregnant and has been diagnosed with gestational diabetes. Her doctor has told her she needs to monitor her blood sugar. What are her rights? Are there any changes Mary can ask for in the workplace to stay healthy while working? Okay, if anybody has any ideas, put in the chat. I'll give you guys a second. Think about that one. Oh, yes, we have somebody say time to check blood sugar under the ADA. Yep, regular breaks, monitor blood sugar and have snacks. Yes. Would she be able to stay home? That, as far as using disability, short time off can be an accommodation under a disability, but it depends on the exact situation. And because this is, again, we don't have all the facts here, this is pretty short, we don't know if that would be an appropriate accommodation for Mary in this situation. But again, short breaks or time off for appointments and things like that are accommodations under the ADA that can be accessible to a person. So as you guys in the chat were said, Mary can be covered under the Americans with Disabilities Act. She can tell her employer that she has gestational diabetes and request an accommodation, and then using the ADA, and then the employers are required to provide it unless it would be an undue hardship. She could request, as people have been saying, frequent meal or snack breaks, breaks to take medication, use the restroom if necessary. And then she's also protected from discrimination, from facing discrimination or unfair treatment because of her disability, gestational diabetes, but also because of her pregnancy under the PDA. So this is a situation where she's covered under both of those because as far as discrimination, but of course it'd be a lot easier to get a reasonable accommodation under the ADA because you don't have that requirement to find a similarly situated individual that's also receiving an accommodation. Under ADA, it's that they must provide it unless it's an undue burden. And then again, ADA, we talked about interactive process. She has to inform her employer about the condition in order to start the process about requesting accommodation. Can't just wait for an employer to assume. Okay, so those were our 2 scenarios. We're going to get into the FMLA, the Family and Medical Leave Act. Family Medical Leave Act provides up to 12 weeks of job protected unpaid leave per year that can be used on a reduced schedule for all at once to care for yourself or a family member's serious medical condition. Family members include a spouse, child, or parent, and the child is under 18 unless they're unable to care for themselves due to a mental or physical incapacity. Examples of using FMLA could be time to recover from childbirth, time off to recover from childbirth, time to bond with baby, or recover from maybe a pregnancy-related medical condition. People, could also use it maybe your baby is sick. We had the formula shortage, switching formula, those types of things, or even established breastfeeding could be also another use of the FMLA. But again, just noting that this is unpaid leave. So that really limits how much time people can really take using this leave. Eligibility criteria for FMLA, that's also another barrier that's preventing people from using this. You have to have worked at least 1,250 hours in the year prior to needing leave to qualify for FMLA. You have to have worked for your employer for at least a year, and you have to work for an employer with 50 or more employees within a 75-mile radius. That really just highlighting here how many workers that leaves out. Part-time workers, a lot of times, they don't reach those hours. People who are just hired. So you always want to make sure that in your situation with your job, double check, look at their employee manual. What are their specific policies around leave? Do you get sick time? Do you get PTO, paid time off, vacation, or anything like that, which can also be used in conjunction with FMLA, but also if you don't qualify for FMLA, you may qualify for something under your employer's rules. So it's always good to double check. You know, and just really highlighting again, we know how many people this really excludes from this type of leave, even on top of the fact that it's unpaid. And so that's one part of the advocacy area, advocacy work that we do is really trying to advocate for those types of laws that are more inclusive to all workers, and also paid leave as being a really big one that can be helpful for a lot of families. When it comes to FMLA, if you know in advance that you need FMLA leave, you have to notify your employer at least 30 days in advance. Of course, if it's an emergency, you don't know 30 days in advance, so it's really as soon as possible. And under the FMLA, your employer can't punish you for taking or asking for FMLA leave, and in general has to return you to the same or similar position that you had before you took FMLA. The law does go into, there's a little bit of trickiness in there, so there is some exceptions that apply, but again, we are happy to work through that with people who call in our helpline and kind of go through the specific situation. Want to also note that FMLA is not a leave of absence. That is something, again, that might be under your employer's policies and may also protect your job, but you want to check with your employer on that and what a leave of absence is, because that is not FMLA leave. And then again, you may be able to use other leave that's provided for your job. So maybe vacation time, sick time, PTO at the same time that you have FMLA so that you can receive some sort of income. Or there might be other options like workers' comp or other types of situations that may qualify you for some employment while you're off the job, but that's not, compensation is not included as a part of the FMLA leave. So we have a question here. So could someone take 4 weeks of full-time FMLA and then 6 weeks of part-time FMLA after birth? So the situation, you can request, as in the, I wanted to kind of go back. So you can request to use it at a reduced schedule all at once, or, you know, so you can say, well, I only need full-time FMLA leave for X amount of weeks, and then also use FMLA leave on a case-by-case basis another time when you need it. So it is not required that it has to be all 12 weeks, and it doesn't have to be at once. So to answer the question, you don't have to take all 12 at the same time. And yes, you could take 4 weeks if that's what you think that you need, and then come back and then take time as needed for other time off issues that may have to do with the medical condition or for you or your child. Okay, and then this is kind of the last one I wanted to get into, the federal break time for nursing mothers law. I think it's not that well known, I feel like, of the law when I've had these trainings. And this is a federal law that requires employers to provide reasonable break time for an employee to express breast milk for a child for 1 year, up to 1 year after the child's birth. And breaks do not have to be paid unless they're concurrent with paid breaks. And employer must also provide a clean private space other than a bathroom where workers can pump milk without interruption. An unfair treatment based on the need to breastfeed is also illegal under this law. And then when I mentioned the, they're not paid, so it's not required to be paid under the law, but if they are concurrent with paid breaks, they do. So if somebody's already being compensated for a break, if they use that break time to pump, they would still be compensated for that break. And also, as far as like creating a clean private space, the space can be temporary or converted space, but it still can't be a bathroom. And it needs to be shielded from view and free from any intrusion from coworkers or the public. Now, this is where it comes into like the limiting factor. This is only applicable to employers and employees covered under the Fair Labor Standards Act, FLSA. So FLISA exempt employees are not covered by the law, which means a lot of salaried employees working executive, administrative, professional, and other industries are not covered by this law. So their employers do not have this requirement. Non-exempt employees, these are typically employees that are paid hourly and are eligible for overtime pay. So all employers are covered by FLISA, the Fair Labor Standards Act, are required, regardless of the size of their business, are required to comply with this provision. But just to note that employers with less than 50 employees are not subject to the FLISA break time requirement if the employer can demonstrate that the compliance with the provision would impose an undue hardship, too expensive, too costly for them to have this. If it's under 50 employees, if they can demonstrate that, they wouldn't be covered. So that's, again, one of those things that we're taking time to notice. That's covering, a lot of people are not covered under this break time law. That's another avenue of advocacy and things that we hear from on our break time, on our helpline, that people are not getting this break time or they're not getting non-bathroom space. And, again, this is cutting out a whole large swath of people when we talk about salaried employees. Okay, so we have another question. So to clarify, employers do not have to allow salaried executive employees time to pump or a private space to do so, unless a salaried executive employee asks for this accommodation under one of these other laws. Yes, you can still ask for an accommodation to pump under, of course, like the PDA or the ADA if it's a situation you're required to pump. I know with, like we talked previously, some lactation counseling, like mastitis, and having time to pump is something that would be something that a doctor would even prescribe. So yes, you could get those accommodations or ask for those accommodations under those two laws. But it's not automatically provided under the federal break time for nursing mothers law. So enforcement. So when it comes to these laws, we would go to the Federal Department of Labor. So as I mentioned earlier, ADA, PDA, that is the EEOC. For this law, we're going to go to the Federal Department of Labor. The Wage and Hour Division specifically enforces FMLA and the federal break time for nursing mothers law, as well as other workplace laws regarding wage and hour, of course. But each issue has its own coverage requirements. So you might want to speak with an attorney with specific questions. And again, calling our helpline, we can work through the details of a specific situation. Everything I'm saying today is really general, and there's nuance in every situation. So you really have to think about that and see how this actually applies to you in your situation. Again, just a reminder, employers cannot terminate you or discriminate against you for filing a complaint with the DOL or participating in an investigation. Okay, so another fun scenario. Kelly is a longtime employee for a large manufacturer. Last year, she worked 40+ hours each week. She is currently 7.5 months pregnant and scheduled to give birth via C-section in a few weeks. What are her rights? Are there any changes Kelly can ask for in the workplace to stay healthy while working? Again, put in the chat if you have any ideas. Hint some of the laws that we just recently went over might apply. I'll give you guys a second to do that. Okay, we'll move on. So yes, we got FMLA in the chat. Yes, exactly. Kelly may be covered under the FMLA. Under FMLA, she can request unpaid time off to recover from childbirth and bond with her baby. But in this situation, she must notify her employer as soon as possible. Also note that she may qualify for additional accommodations under the Pregnancy Disabilities Act we talked about, or the Americans with Disabilities Act, depending on the circumstances of her pregnancy. So always keep in mind, these laws can be on top of each other. It's not just one can apply in each situation. And then with FMLA, just kind of noting those requirements that we talked about, that does cut out a lot of people. So having worked for at least a year, We know that she's done that. She's a longtime employee. Over 1,250 hours. We know that she worked at least 40 hours each week last year. So we know that she hits that. So just keeping those in mind, also having to keep in, do you actually qualify under FMLA? Which in this situation, we can believe that she did. Okay, and if she faces complications before birth, can she take FMLA early? So FMLA can be used for her own medical condition. So if there's a serious medical issue that she's facing, of course she can, and it's emergency, again, notify as soon as possible your employer that you need to take FMLA leave. So it's not just restricted to just the time that she gives birth and after. So if some other complication does come up, it is something that FMLA is something that she can use. Okay, and this is our last scenario here. Keisha is a full-time, overtime eligible employee at a large warehouse. She has a 6-month-old baby girl and is currently breastfeeding. She would need to pump at work to maintain her supply. What are her rights? Are there any changes Keisha can ask for in the workplace to stay healthy while working? So again, any thoughts or ideas maybe on some laws that we just recently went over? Give you guys a second here. Yes, okay, yes, secluded place to pump, break time law, exactly. She may be covered under the federal break time for nursing mothers law. Under the law, Keisha would be entitled to a reasonable unpaid break time to express breast milk. The employer would have to provide a clean, private space other than a bathroom where she can pump milk without interruption. You know, the key things here that I want to highlight is she's a full-time, overtime eligible employee. So we're kind of in this situation, we're assuming that she is FLISA non-exempt. Let's see. And we also want to note that it can be a temporary space. We have a question: is there a maximum amount of break time allowed under law? It doesn't specify if there's a maximum amount of time, just a reasonable amount of time. So again, get into that weird legal standards. So again, each situation would be a little bit different and kind of go into what is reasonable or not. And of course, looking at case law and other situations like that in each specific situation. But there is no set time that says it's only allowed for 30 minutes a day or anything like that. Now we're gonna just kind of get into kind of wrapping up. I've given a lot of information today. I'm aware it is not the most engaging and fun information, but we just want you to know that we have this information on our website, so you can easily access this. www.abetterbalance.org. We have a workers' rights hub set up by state. You can go, you see here, divided up in tabs like caring for your health, time off, navigating pregnancy at work, all the issues that I've talked about. We have them available and resources available on our website. And then we also have our free and confidential legal helpline, which is 1-833-NEED-ABB. And we're happy to talk about your specific situation, the rights, and how to go about approaching your employer in your situation. We also have developed Alabama-specific one-pagers. So one that we have here is our Working While Pregnant in Alabama, Know Your Rights Guide. Kind of gives a kind of quick, brief overview of a lot of the stuff that I've said today, just not as many words I've used. You know, we don't expect people to be experts, but hopefully these types of Know Your Rights Guide can help identify issues and help issues spot in their workplace, or if you're dealing with a client that is having these issues, you might be able to say, well, hey, I think there's some law that's revolving around that might assist you in this situation, and might refresh your memory on this very long presentation that I've given you today. And these resources are available on our website. And then finally, we have just our contact information to keep in touch. We have our, again, free and confidential legal helpline. We have our website with Workers' Rights Hub. We betterbalance.org. And then we also are on social media, Twitter and Instagram. I kind of want to say that we have gone through a lot, and I hope that I was able to at least highlight some of those core issues of advocacy that we are aware of and know and fighting for to make different. We know these laws aren't the best for everybody. They're not covering everybody. They can be much better. We know that paid leave, paid sick time, reasonable accommodations without having to go through what we've had to describe today is the best for really everybody and all for women. And so we do engage in those advocacy efforts. So if you're following us, you can definitely see more of that. Get our newsletter, see how you can engage with us and try to advocate for these laws and make things better for really everyone. So I'll just leave that up. And then if there's any questions, you can come off mute, you can put them on the chat. I'm available. Also, if you want to email me, which was back in that first slide, lbooth@abetterbalance.org. And I'll just go to the chat now and see if there's anybody has questions in there. Okay, yes, I'm happy I was able to answer some questions and get some information for your sister. Well, great to hear that. Okay, I have a question here. Does the PDA cover employees of public state institutions or only private and or federal employers? So the PDA covers all employers with 15 or more employees. There's no distinction if it's a private or public employer. So I hope that answers the question there. And if there's any other questions, I see Julie's here. Private. Oh, with the PDA. Let me go back. You see that? I don't want that slide to say that and confuse anybody. Oh, private employer. See, no, the private employer, it actually is all employers. It's not just a private employer. So thank you for pointing that out. I need to change that on the slide. Sorry about that. Thank you. Okay, so we have Julie here.
I certainly did not mean to interrupt by spotlighting myself as well. I just wanted to be available before you said thank you and goodbye and people started clicking off. I just wanted to thank everyone for participating tonight, and thank you, Lauren, for providing this information. I know some people were participating, listening out for what applied to them personally or family members or friends. And then I also know that there were people here listening out for how they can best support the partners that they work with or the clients that they serve. So I appreciate all of this information. And if you're a UAB student and you're not a member of the Maternal and Child Health Student Association, we'd love to have you join. It's free of charge. You'd just be joining with a lot of other undergraduates and graduates on campus that have a special interest in learning more about maternal and child health and then promoting maternal and child health and developing leadership skills and all kinds of other good things. So Lauren, thank you so much. And I wish you all a really great night.
Yes, thank you guys for engaging with me and hanging in there. And I hope you guys have a good night.